Hello everybody and welcome to the first of our Landlord Law Legal Cases webinars, which is going to be on the case of Pease and Carter. The barrister who's going to be explaining the case to us today is Alice Richardson. Alice is a specialist landlord and tenant barrister who deals with housing and property work, and she's based in Trinity Chambers, which I think is in Leeds, isn't it, Alice?
Yeah, we've got one in Leeds, one in Newcastle, and I'm in the Newcastle branch.
So Alice is going to be talking about Pease and Carter, which is all about mistakes in Section 8 notices. So, Alice, would you like to explain the case to us, starting perhaps with the background to the case?
I will, yeah. I've set out on the slides here what we're going to cover. So the background to the case, a bit about Section 8 notices generally, the issues that this case raised, why it went to the Court of Appeal, the arguments that were used at the hearing, and then the wider implication for notices and other possession notices. I was counsel for the landlord in this case. And what had happened was the landlord had granted the tenants, as two tenants, on the slides I've just called them T and L, an assured short-hold tenancy back in 2007. The property was actually, I've described it as a cottage, some kind of small stone building on quite a large estate. My client, I think, lived in the main house and owned the entire estate. The tenant actually worked for my client on the estate as some kind of maintenance man / handyman. So there's an interesting dynamic between the parties. The rent was originally £800 a month and was subsequently reduced later on to £500 a month. Something happened between the parties leading to the tenant to quit his job working for us in around March 2018 and subsequently stopped paying rent in April 2018. Not within my experience or within this relevance to our case, but there was a separate claim brought by the tenant against the landlord in the employment tribunal as an employee against an employer for an unfair dismissal, which he also lost. So there's all sorts going on in the background to this case that aren't necessarily relevant to what we were talking about.
Yes, I mean, just thinking that situation, I mean, sometimes in that situation, the tenant will have a service occupancy rather than a tenancy, won't they? So I assume that the tenant wasn't required to live in the property because of their work, which would have...
No, I think, I might be wrong, but I think that actually when he first took up the tenancy in 2007, I don't think he did work for us. Mm-hmm. I think he later worked for us, and maybe that was why the rent was reduced later on as a part of that relationship. But no, he was definitely being granted a fully assured short-hold tenancy rather than a service occupancy. Otherwise, we probably would have never been in the difficulties that we subsequently got into.
Wouldn't have had a problem, yes.
So this is in March, April. There's no rent being paid, and we get to November of 2018, and the landlord's agent serves a Section 8 possession notice on the tenant. Well, on the tenants, because it's a tenant and his wife, worker and his wife. The renter is by that point over £3,500. The notice was signed and dated on the 7th of November 2018, but there was a typo, which was that we'd said that court proceedings would not begin until after the 26th of November 2017, rather than the 26th of November 2018.
It's easily done, that, isn't it?
It is easily done. It's probably surprising to do it in November. In January, you can understand how easily done it could be. November, these things happen, I suppose, and it's a fairly straightforward error, and what I thought was a fairly obvious error from the very beginning. The standard note on the form, on the prescribed form that we'll talk about a bit later, says that where the landlord is seeking possession on the grounds that we were relying on, court proceedings cannot begin earlier than 2 weeks from the date the notice is served. So served on the 7th of November 2018, said to expire, or the proceedings couldn't begin rather until the 26th of November 2017 rather than 18. What does the law say? So kind of taking it a little bit back to basics, because most people will be no doubt aware of the two routes to getting possession on an AST. There's the Section 8 route or the Section 21 route. I'm just going to talk about those two routes a little bit, because you'll see when we come to what happened in this case that it was necessary when it came to the Court of Appeal for me to take them through both routes and what they mean and what the statute requires landlords to do to satisfy those. So no doubt everyone's aware, Section 21, commonly known as the no-fault route to possession. You've got to meet the now fairly lengthy preconditions before you can serve a Section 21 notice, and you can do so once fixed terms expired. That's all kind of me generalising, but I think most people are probably familiar with the complications that there are to Section 21 notices now. And I don't know in this case, because I wasn't involved at that stage, but I suspect there's reasons why we went down the Section 8 route rather than the Section 21 route. There is now a prescribed form. Most people, when they serve a Section 21 notice, nowadays will use the 2 month and a date specified as the last date of the period of the tenancy, plus a savings clause to say, or if that date's not the last date of the period of the tenancy, whichever date is, which avoids the type of problems that some of the cases that we're going to talk about got into. But that's the basic for a Section 21 notice. Section 8 notice, again, most people are probably aware, it's basically landlord proving a breach of one of a number of grounds. In this case, and what's relevant to this case of rent arrears, the grounds are set out in Schedule 2, and there's mandatory and discretionary grounds. As we'll come on to in our case, we're relying on all of the rent arrears grounds, so both mandatory and discretionary. Again, there's a prescribed form, and you have to use a prescribed form or a form that is substantially to the same effect. Now, in that form, anyone who's seen it knows you've got to include certain details, including the date that possession proceedings will not begin earlier than, and you set out the date. And the Act provides certain timeframes for various grounds, although at the moment they're all 3 months because of the situation we're currently in. But usually, for the grounds that we were relying on, there was 2 weeks, as I said earlier. These are the grounds that we were relying on. The ground date, as everyone knows, mandatory if certain thresholds are met, i.e. in our case it was a monthly rent, so 2 months rent in arrears. And then grounds 10 and 11, some rent arrears or persistent delay in paying rent, the discretionary grounds. Anyone who doesn't know, if there's a mandatory ground for possession, generally means the court does not have jurisdiction, or doesn't have, discretion to do anything other than make a possession order if those conditions are met, whereas under discretionary grounds, they have to consider whether it's reasonable to order a possession order. So,
yes, I mean, just chipping in there, often landlords will use the rent arrears ground because they also get a CCJ along with the judgment as well, so that it's sort of like a job lot, so they if the tenant's got any money, which is usually the problem, they can go and enforce it. I think also some larger landlords will go down that route as a matter of principle, because they'll want there to be a CCJ against the tenant if they don't pay. Yeah.
It's also, I suppose, in some ways a better way to protect yourself, because there are, in my experience, maybe it's because I'm a barrister and things only come to me when they've gone wrong, but in my experience there are lots of things that can go wrong with Section 21s because there's not the same checks in place.
Yeah, but conversely, there's a lot more defences that tenants can bring into Section 8, like saying that, there's rent arrears, that there's repairs that need to be done and so on. So, I suppose it's swings and roundabouts, really.
And that is something that happens, you'll see in this case as well. So to add to the notice problem, there's various other issues. I mean, this is one of those cases, everyone has these cases occasionally where everything that could possibly be raised and thrown at it is raised, and every kind of possible problem that you could run into, you seem to run into. But the first problem was obviously the date was wrong on the notice. So there was an argument that it didn't comply with the Section 8 requirement to give that date, and that's obviously a statutory requirement. The regulations provide for you to do so. And I don't know about you, Tessa, but in my experience, the court's approach when there was an error has often been quite a strict approach, which is to say, right, notice isn't valid, off you go, and the landlord will have to go and serve a new notice and issue a fresh set of proceedings.
Yes, I mean, I can understand that actually, because I think a lot of judges take the view that they are depriving someone of their home, which is quite a serious thing, because, they are potentially being made homeless. And, sometimes if people are made homeless, it sort of knocks them off life's perch, as it were, and sometimes they never get back on again. And if they've got kids, they might get taken into care. It's a very, very serious thing. So I can understand why the court's approach is strict.
Yeah, definitely. I suppose the difficulty is if there's any kind of rule with no flexibility will always lead to potentially unfair results. So if we had an approach that we did previously, which not across the board, but generally seemed to be, like I say, that quite strict approach, that did lead to circumstances where you might be a landlord with, as in our case, not insignificant rent arrears. And if you had to go away and serve another notice, go through that notice period again, serve proceedings again, wait for a hearing again, the rent arrears are going up and up.
Yeah, I mean, I suspect what a lot of people are saying to themselves is, when did they spot this error on the notice? Why didn't they serve another notice before the proceedings were issued? Because the notice period is only 2 weeks. It's not like Section 21 where you've got a 2-month notice period. Yeah. I mean, did they not spot it before they issued proceedings?
No one noticed. They issued proceedings. A first hearing was listed, which I think I'll come to now. And that was at the end of January 2019. So
can I just ask, did they act in person or did they use solicitors?
So for the notice stage, I think they used an agent, and then they instructed solicitors to issue the proceedings.
I'm surprised the solicitors didn't pick up on it.
Yeah. So we get in front of District Judge Adams in Darlington, who immediately looks at the papers and says, well, hold on, this notice is invalid. But having some argument about that, he agreed that the notice was obvious. It was obvious what the date should have said. And we'll come to it, but we agree that this was a wrong approach. He allowed the landlord to amend the notice to rely upon it. So that element, the amendment bit, I think we accept, I accept in the Court of Appeal, was wrong, and he wasn't entitled to do that. But what he was entitled to do is say, well, this error is so obvious that and no one had raised it. The tenant hadn't raised it. The tenant was at court. There'd been no prejudice, that kind of thing. What the tenant did raise, as I suggested earlier, were disrepair issues. So the judge gave the tenant permission to file a defence and counterclaim raising the disrepair issues, and then give some directions moving towards a trial. It's probably a little bit surprising that, given the notice issue had been raised, in a 5-minute possession hearing notice by the judge, that if his inclination was that it was valid, maybe should have left that issue as a triable issue and ordered that the parties file something in writing about that. that could have been something the tenant could have raised in a defence, and then you could have had a properly pleaded, full argument about it rather than a 5-minute hearing. But
I have to say, if this had been my case, and I have had, because when I practiced as a solicitor, I did quite a lot of possession cases. I probably would have tried to end the proceedings by agreeing with the other side that there'll be no liability for costs, and then deal with the disrepair, serve another notice, and start again. But obviously, this approach they decided not to take.
Yeah. I think because of the judge in the first case, the first instant judge has said the notice was valid, then I mean, if he'd said it's a query, or if he'd said it sent it off for a trial on that issue, or if he'd said it's not valid, then yeah. But because he'd said it was valid, I think that left them in a strange position where if they'd withdrawn the proceedings and issued a fresh set. And I can see a question coming. It was the landlord not aware of the disrepair issues? I think. I don't think that he was aware of the disrepair issues, and I can't really say too much about that because I don't think that element of it is actually entirely resolved. But it's safe to say that it's the disrepair counterclaim is defended.
I mean, that presumably that wasn't part of the appeal that you were dealing with, but I mean, sort of generally with disrepair issues, there's often a question of notice, because if there's no notice, then the landlord often isn't liable, is he?
Yeah,
I suspect that was part of it, but that's not really what the appeal was about. So we can only speculate.
Yes, quite. So what happened next was that the tenant sought to appeal the decision on the notice point. So there's in the background going off this disrepair issue, and then in the meantime, the tenant sought permission to appeal on the notice point. And another reason, I suppose, why my client didn't at this point go, oh, well, let's withdraw these proceedings and issue a new one, is that the tenant was initially refused permission by the circuit judge, who looked at the papers and said that it was doomed to fail. So with the circuit judge giving that opinion, it's not really surprising that the landlord didn't think, oh, well, I'm going to go back. And at this point, we're in, I think, maybe March or something of 2019. I'm not going to serve new notice now. So permission had been refused. The tenant then asks for oral renewal, which, just to explain a bit about that, is if you've been refused permission on the papers, in these circumstances, you can ask for the court to reconsider an oral hearing. So at that oral hearing, and again, I wasn't at that hearing, I don't know what had happened between the judge thinking it was doomed to fail and the judge thinking it wasn't. But at that oral renewal hearing, the circuit judge gave permission to appeal. So at this point, we're going from the district judge to a circuit judge. Landlord, at this point, we put in a response basically agreeing that the first judge couldn't have given permission to amend, but saying, look, that notice was valid when you rely on the reasonable recipient test. So we're going to kind of segue and break into what the reasonable recipient test is. And the test that the case that it's most often, I think, attributed to, and kind of sets out the basic rules, is Mannai and Eagle Star, and that was a case, a business lease case. So it was a contractual notice served under a break clause. So slightly different to our type of case, which is a notice that you have to serve by virtue of a statute, so a statutory notice. This is a contractual but unilateral notice. Landlord given the wrong date. In that case, it got the day wrong, 12th of January instead of 13th of January as being the end of the period of the lease. That case went all the way up to the House of Lords. So the House of Lords was the equivalent of what the Supreme Court is now. So it went all the way up to the House of Lords, and the House of Lords held that a contractual notice could be valid even when there's an error, if it was sufficiently clear and unambiguous to leave a reasonable recipient in no reasonable doubt as to what it was supposed to say. So there's often in law, there's a concept of a reasonable person. This is a reasonable recipient. So it's not a subjective test. It doesn't depend on what the individual reader of the notice did believe. It's what a reasonable person who'd received that notice would have understood it to mean.
There are generally in sort of the legal world these legal characters that pop up from time to time, like the officious bystander is one of my favourites, and the man on the Clapham omnibus, who are not real but a sort of stand for what would sort of an everyman approach, I suppose.
Exactly. And that was something that we argued a bit about in front of the circuit judge, but it doesn't form part of what this case ultimately decided. There were then, and I haven't set them all out because there are a lot of cases, and if anyone is that interested, you can read the judgment, the Court of Appeal judgment in our case, where they set out and go through pretty much all of the previous Court of Appeal cases about statutory notices. Most of them are actually cases about what some people may remember as being quite important cases, which were about Section 20 notices. But none of them are possession cases. Generally, it was held that where the statutory purpose is met despite the error, then the notices were valid under Mannai. And in those cases, they looked, the statutory purpose of a Section 20 notice was to tell a tenant that they were an assured short-hold tenant and not an assured tenant. So in those cases, quite often it was that purpose was met. It was just that there was other errors in the notices. So there'd been nothing that had gone to the Court of Appeal about possession notices, basically. I've said here there is some overlap between the reasonable recipient test and the question of whether notices are substantially to the same effect despite errors. So I think I said earlier that there's a prescribed form for these type of cases, and there often is for statutory notices, a prescribed form, but then the regulations say you must use that form or something substantially to the same effect. And there was a bit of an overlap in the case law between whether something was substantially the same effect despite the error, and whether the reasonable recipient test was satisfied despite the error. And an important case for us as the landlord in this was that the substantially to the same effect rule applies whether the defect was an error in the form or in the information inserted in the form. So I think most commonly you would think the substantially to the same effect provisions would apply where a landlord doesn't use the prescribed form. Maybe they use a slightly out of date prescribed form, maybe they use another version of the form, maybe they copy the information from the prescribed form into their own version and amend it and something goes wrong. That's, I suppose, what people would commonly think the substantially to the same effect rule is there for. But this case, B. Osborne and Dior case, makes quite clear that test can also apply where the information that you required to insert in the form has gone wrong. It's quite interesting and very helpful for us. So in the first appeal, in front of a circuit judge in Teesside, he agreed with the district judge and with me that the error was obvious, that the tenant would have known that it was supposed to say 2018 and not 2017. That's fairly straightforward. He agreed that under Mannai, the notice would have been valid, but held that Mannai did not apply to possession notices. So kind of a strange way round that he went. But the reason for that was this case, Fernandez and McDonald, which was relied upon by the tenants' lawyers. And I've said it's a bit of a strange case. It was described as a puzzling case in the subsequent case of Spencer and Taylor for various reasons which are not relevant to what we're talking about. But in the Fernandez case, a landlord had served a notice under Section 21(4). They'd given the wrong date after which possession was required. And it was Lady Hale sitting in the Court of Appeal at that time who basically said Section 21(4) requirements are clear and precise, so there's no scope for applying Mannai. And I've set out on the next slide here the quote that she gave that was relied upon by the tenant. She said, "It's not difficult for landlords to comply. They know when the period ends. Not a case where the consequences of failure to comply are particularly serious because a defective notice can be cured the next day. Even if the point is not noticed until it's taken to court, a valid notice can then be given. And the landlord is not unwillingly and unwittingly saddled with a tenant who has security of tenure." So the last part of that is in reference to the Section 20 notices cases where people had served Section 21 cases, brought possession claims, and then tenants had showed up and said, "Aha, there was an error in your Section 20 notice, and actually I'm an assured tenant and you can't rely on Section 21. So it's a fairly straightforward point. Get your notice right, and if you can't get it right, you just serve another one. I suppose the difficulty for my client by this point was we were now, I think, nearly a year down the line. Rent arrears were racking up. No rent was being paid at all. Rent arrears were racking up, and we'd been successful in front of the district judge and now had a circuit judge saying, actually, your notice isn't valid. We also had the ongoing proceedings in the background, proceeding towards a trial. So it's not as easy, I suppose, in that circumstance for a landlord to just go, oh, well, I'll just take a hit and serve another notice, especially because I think my client didn't have much hope that they would ever get their money.
Yes, I suppose also the further you go down a case, the more costs are racked up. And if you just pull out, you automatically become liable for the other party's costs, don't you? So that's...
Yeah, that's true. And I think this was a case where the landlord and the solicitors as well, it's just a case where they were willing to fight the point. And they had the benefit of insurance, and the insurers were willing to fight the point. And it was one where I suppose you're right. Yeah, you could just go away and serve another notice. You could just do that. But by that point, as I said earlier, you've accrued, the tenants have accrued rent arrears. You've got the costs of paying the solicitors if you've paid a solicitor, an agent, whoever it is, to issue the claim. You've got to court. You've paid someone to go to court. So, if you've not got decent insurance, that's quite a hit to take if you're going to do it again. This isn't obviously, it's not only applicable to a private landlord as well. I mean, you could be a really large private landlord, you could be a really large housing association and have these type of problems. And if you've got an error and it happens multiple times, that's, the costs are racking up of doing that. And I suppose, like you say, you've gone that far. Why not just argue the point and get an answer from the Court of Appeal?
I suppose also it's advantageous for the insurance companies to know where they stand as well. It's useful to have a case that sets something out so you know where you stand.
Yeah, and I suppose, and at that point, I think for us it would have been cheaper to just get a permission decision from the Court of Appeal than to issue a whole set of possession proceedings again. So. Yeah. But I mean, what the judge had done in this one was allowed the appeal, said that the notice was invalid, but then he'd exercised his discretion to dispense with the notice on the discretionary grounds. So that was, the proceedings were still going on the discretionary grounds with that and the disrepair counterclaim. But as you say, by this point, I think it's become, I suppose, a matter of principle. As I've set out here, could have served a new notice and issued fresh proceedings, but because of the wider implications for landlords and because we had the benefit of insurance, the landlord sought permission to appeal to the Court of Appeal.
Which presumably was granted. Yeah.
So I've set out here, it was a second appeal. So in order to get permission for a second appeal, because even though the first appeal was the tenants and not ours, it's still, if there's already been an appeal in the case, in order for the Court of Appeal to be entertaining it at all, it has to be a point of wider importance, which Lord Justice Patton agreed that it was. and granted permission. Interestingly, I realised that Lord Justice Patton, in his career as a barrister, had been counsel in the Mannai case. So perhaps not surprising that he thought this was very important.
Yes.
Because the trial had been listed, we got a fairly quick Court of Appeal hearing listed. But we then encountered another problem, which was that the tenant's solicitors applied to come off the record. He had been legally aided. We don't know and are not privy to what exactly had happened or why they came off the record. But the upshot is he was left without a lawyer, with a Court of Appeal in something that we were saying of wider public importance listed. My view was at this point, we don't want the tenant to be unrepresented. We don't want that for all sorts of reasons. I suppose we wanted the point to be properly argued, which with a one-sided appeal it wouldn't be. It potentially would mean that the Court of Appeal's judgment wouldn't hold as much force because it was a one-sided appeal.
So it was really necessary, if it's to be a proper precedent, to have proper argument on both sides. Otherwise, people might say, well, the judge only really heard one side of it.
Yeah, exactly. And also, it's the Court of Appeal. You don't want someone not represented. You want to have a proper argument about it. And the other risk, I suppose, was that if the tenant didn't have representation and in person showed up or wrote to the court and said, well, I need an adjournment, we would have lost the hearing date. So there's practical reasons as well.
So the good old pro bono system, which is a posh legal word for free, really, isn't it?
Yeah. So I said to my solicitors, I think you should write to the tenant and say, these are the other kind of advice agencies that you could go to, or you could contact what was the Bar Pro Bono unit, now Advocate, and ask them if they would represent you. And he must have done so because someone came on the record. The barrister agreed to take on the case for the tenant for free very late in the day, I think a couple of days before the appeal. This was all happening. I think I got his skeleton argument the day before, or maybe 2 days before the appeal, which wasn't ideal because it meant that I did not know what the tenant was going to argue. From a kind of personal point of view, I have been in cases in the Court of Appeal and Supreme Court before, but as a junior, which means being led by someone more senior. I had never been in the Court of Appeal on my own. I had been fairly confident that I could do this case on my own, but getting 1 day before without any idea what my opponent was going to argue was slightly nerve-wracking.
Yes.
Not least because when we received the skeleton argument, the tenant's lawyers were arguing a completely new point.
So what was that then?
It was that it was not obvious, and that the circuit judge had been wrong to say that it was obvious what the date should have said. So he said it was obviously an error. It was obviously, we hadn't intended on giving minus 50 weeks notice, but that it wasn't obvious what the correct date should have said. His argument basically was, if you've got the year wrong, what's to say you haven't got the whole date wrong? How does my client know that you didn't just copy and paste from a form you've used previously and that's just a precedent form that you've used previously and you've left the date in from the last case or something like that? So that's a point that normally would have required a respondent's notice, and obviously we would have had time to put in a skeleton argument addressing that point. I then had to decide, well, hold on, do I make a fuss about this, or do I just go for it and get on with it? Because again, the risk of causing a fuss about it, saying this is all very late, is that we lose the appeal date. So we decided to just get on with it, really. Get up to the Court of Appeal. We had 3 Lord Justices, so Underhill, Floyd and Arnold, and they had to consider the new point made by the tenant, plus our arguments that Mannai did apply, and that in any event, the notice would have been substantially to the same effect. As I said, this was my first Court of Appeal case on my own. So it was, as I said, slightly nerve-wracking arriving at the Royal Courts of Justice in London and sitting waiting to get on with it.
Yes, it's always very nerve-wracking, isn't it?
Yeah, even if you're really confident in your case, there's always a moment of, oh God, so the Court of Appeal went through all of the previous case law. I took them through everything, and the case law wasn't all entirely consistent. There wasn't always exactly the same approach being taken. So we had to go through all of that. And the Court of Appeal ultimately held that the Mannai test does apply to statutory notices served unilaterally, including Section 8 notices. They kind of gave some takeaway points, that I've called them, points of guidance, really, having gone through all of the case law. First one being that if this reasonable recipient, so this normal person, would realise that the notice contained an error, would appreciate what meaning the notice was intended to convey, so what, in our case, what the date was supposed to be, then that's how you interpret the notice. Fairly straightforward, basically what Mannai says. But then they said, in a statutory notice case, you've got to go on to consider whether, so interpreted, the notice complies with the relevant statutory requirements, which involves considering the purpose of those requirements. So in our case, what's the purpose of a notice that gives the tenant a date after which possession will be given up? What's the purpose of giving the 2-week period? And there's various cases that say that it's for, a shot across the bows, I think they call it a possession notice, because it gives the tenant notification of what we say that they've done, and then they've got a period of time to correct it or to sort themselves out with somewhere else to go before you issue court proceedings. So in our case, whether the notice interpreted as it should have been, which was the 26th of November 2018, complied with the relevant statutory requirements. Well, that did, because that was over 2 weeks' notice, and the purpose of those had been complied with. They then went on to say, again, not necessary, because they'd found for us on the first bit, that even if a notice didn't precisely comply with the statutory requirements, it may be possible to conclude that it's substantially to the same effect if it fulfills a statutory purpose. Obviously, that's not that wasn't delved into in any great detail in our case, because we weren't in that situation. But they've said there might be cases where you don't comply with the statutory requirements, but it's still substantially to the same effect because the purpose of the statute is met. As to the Fernandez case, they said that the interaction with the Spencer and Taylor case had caused confusion, which I think is probably right, and that the Court of Appeal held that the Fernandez case did not mean that Mannai didn't apply to Section 21 notices. On the tenant's new point, they said a reasonable recipient would have realised the date was the 26th of November 2018. They didn't accept the argument that it could have been 350 something other different days. And they said a reasonable person would have realised that's the error, and that if there was any doubt, look to the cover letters. Because the point had been raised so late, it's not a point that we had I don't think I'd ever even seen the cover letters at this point. But when the point was raised, I said to my solicitor, well, was there a cover letter served with this notice? And she said, oh, yes, the cover letter. And when I got it, I did laugh when I got it. It had in bold writing about 5 times across the letter, 26th of November 2018, 26th of November 2018, 26th of November 2018. So because the point had been raised so late by the tenant, I said to the judges, well, look, if we'd known about this, we would have asked for permission to show you these cover letters. So they agreed to have a look at the cover letters, and then basically said, look, we think without the cover letters, it would have been clear what the date was. But if there was any possible doubt, it was fairly clear by the cover letters what the date should have been.
I suppose even if it had been a cover letter which didn't put that date in bold, normally a cover letter will be dated the correct date.
Yes.
And you will be able to match the two together to show that it is obviously an error.
Yeah, and I mean, some of the previous cases have done just that, and it's one of the arguments that I made. I think I took you at the beginning to a slide that showed the notes that are on the prescribed form underneath the part where you insert the date, where it says if you're relying on these grounds, you have to give 2 weeks notice. So the court said, look, well, that's clearly, it's not exactly 2 weeks between the 7th and the 26th, but it's obvious when you add in a couple of days for service and so on, that's 2 weeks later. So obviously that was the right date. So yeah, in this specific case, luckily for us, they agreed, served the statutory purpose, given the tenants 2 weeks warning, and that they were also substantially to the same effect, that the test applies not just to information inserted in the form and not just to the wording used. We've talked generally, I suppose, about the wider implications that this has. Obviously, this specific case considered Section 8. It's fairly obvious to see how it could apply to other types of possession notices. They specifically mentioned Section 21 notices, but it will have wider implications for all sorts of different types of tenancies, different types of possession notices, and even for other types of unilateral statutory notices. So by unilateral, I mean a notice that's served by one person on another. But I've said on my note, it's not a get out of jail free card for all mistakes. It's not a case that says, well, if you make a mistake, the notice is still valid. Certainly doesn't say that. You have to go through the test. What would the reasonable recipient think? And then based on that, would it comply with that interpretation with the statutory requirements? And there may be cases where the errors are just so bad that it can't possibly be said that it complies with the statutory requirements.
I mean, really, when you are serving these notices, it is so important to get them right, because even if you are able to take advantage of this decision, you're still going to have problems. It's going to make your litigation more expensive. It's going to delay the date for possession. Your tenant's not paying rent. So it's very much something to be avoided.
Definitely. I mean, there's always, whenever there's a case like this that's gone to the Court of Appeal, got some, publicity and being reported, there's always going to be people on the lookout for the case that comes after it. So any kind of potential areas in the judgment that could be interpreted differently, there will be people on the lookout for the right case to run those arguments, to have those arguments, and you don't want to be the person. You don't want to be the next test case. So yeah, get your notices right. But as you said earlier, these things do happen. No one picked up that the year was wrong, because you flick through, you go, right, if they've done everything, yeah. It's fairly easy to see how that, it wasn't until the date of the first hearing that someone went, hold on, this date's wrong.
Yeah. There's an interesting question that's popped up. If there is some people have argued that the notices, in particular the Section 8 notice, which has been amended by the government to comply with the Coronavirus Act, and there has been an argument saying that those amended notices are not actually valid because they weren't amended by statutory instrument. If that argument was raised, would this case serve to sort of validate, as it were, the notice served by the landlord?
I think so. Yes. I mean, I don't see how any landlord can kind of, from a practical point of view, be criticised for using the form on the gov.uk website, especially because that form does. And largely, from one slight point, which I can see someone else has raised, reflect what's set out in the Coronavirus Act in Schedule 29, I think it is. I think this would definitely support that. It may also support an argument where someone's used the wrong notice during that period, but nevertheless given the 3 months. But it all depends on an individual case. And as I think I've said, I think probably on the next slide, it's in each individual case, it's for the judge to decide. And I said there, yeah, the new prescribed possession notices, it's something that we'd anticipated people might have questions about. And one point that I'd noticed this morning, which someone's raised as a question, is when you go on the gov.uk website, download the prescribed form as amended, it sets everything out, all very sensible, until you get to paragraph 3, which is the one that says we intend to seek possession on these grounds, and you insert the grounds and then you insert what the grounds say. And bizarrely, completely bizarrely, whoever has uploaded this notice or made this notice has left in halfway down the paragraph, I must pay my rent. So
yes,
but absolutely no idea what someone's just been messing around, whether it was a personal reminder to them to pay their rent. I have no idea what's gone on there, but that's ended up in the prescribed notice that appears on the gov.uk website. I saw some people suggesting, well, does that mean that is now the prescribed notice, and if you take it out, it's not the prescribed notice anymore? I think it's an amusing point, but
yes, I mean, I'd also say that if you are listening to the recording of this sometime later, I suspect that if you go and download the form, you will not find that sentence there. I would imagine it will be removed at some stage.
Although I definitely saw this, I may have been earlier this week. It's definitely a few weeks or days ago at least that I read people talking about this on Twitter, and you would have thought it would have been corrected by now. So I was quite surprised when I downloaded the form this morning just to have a look at to see that it's still there. Who knows, maybe it'll go away shortly. Yeah, someone said this is weeks old to my knowledge. I think that's right.
Yeah.
I think if it was me, I would just take that out and serve the notice. I don't think anyone's seriously going to argue that should be in there. and if they did, you can rely on Pease and Carter to say the statutory requirements. That is not part of the statutory requirement.
So that's an advantage of this case. It's serving its purpose in clarifying the law.
All it might do is confuse a district judge who looks at the notice and says, why have you written that? And you go, I didn't. That's just in there.
So in this case, presumably the landlord did actually get possession in the end.
We haven't got possession yet. There's a trial still listed to deal with the disrepair.
Right, okay. And if the disrepair claim is won, then the compensation for the repair will offset the rent arrears. I suppose that's the argument. So they're staying it.
That's certainly the argument, yes. But last time I had any involvement with this case, I think the arrears were over £10,000.
Good God, yeah.
Yeah.
So that, ladies and gentlemen, is why you need to take enormous care with your notices to avoid having any errors in them.
Yes, exactly.
Because even though you may win at the Court of Appeal, it's going to cost you a lot of money.
Yeah, and a lot of time.
And a lot of time. Yes. Okay, well, look, thank you so much, Alice. I think we're not far off the allotted time. Thank you so much for taking us through the case. It's been very interesting for me, and I'm sure it's been very interesting for people on the call and for people who come and watch the recording later. Thank you everybody for attending, and thank you, Alice.
No, thank you for having me on, Tessa.
Okay, I shall close down now, and the recording will be available in due course. Thank you, everybody.
Thanks, bye-bye.